Item number 2, under extension of interim, 3 and 4, matter. They will transfer page. Before 24. Earlier, Honorable Justice Tira order for 30.
No, it's all right, but what is the suit about?
By the
Yes.
number 2, that is 76.
71. Item 2 is 71.
কিছু হয়নি মেনশনিং করলে এমনি কিছু হয়নি এটাই ছিল এরকমই ছিল
Only for the injunction. Only this injunction is that is last word by the husband filed against the petitioner and in-law are missing.
What?
Husband filed by the
No, what is the suit about? What injunction? No.
There is not to restrain him not to enter into things.
Have you annexed the plaint?
Yes.
Which page? Which page?
I have given the page. There is no last part. With next time, it is the original plaint and sound. After page number 70. 70, it was 70. And internal found and page number paragraph 36. A decree of injunction, declaring injunction, restraining, keeping us
মেনশনিং ছিল তারপরে
How can it transfer otherwise? Tell me. Suit relating to immovable property. Declare suit for
injunction.
and Who is appearing for the husband?
Then towards okay,
Where is he?
Another complaint that also will me today is around 27 and 30. Again, to so that I write in mother-in-law, mother-in-law, and husband. Another similar.
For what reason?
Cross factories has opened. So total 5 suits has been filed again.
No. This is a suit by the husband for injunction. Now, let us not go into the merits of the matter. What are the grounds of transfer?
This the lady is actually a court.
The-
He has no right to come to this festival. That is been and the court has been filed. All are fake. And it's not
you-
speculative and harassing.
No, where have the in-laws and the wife filed the suit?
In-laws has this sleep.
Siliguri.
So all
But this is, I find, in Alipurduar.
Division of fight against the opposite party as well. Or domestic 125 and domestic.
That is in Alipurduar.
Alipur.
So why you are asking transfer to Siliguri? Why?
I asking for Contempt civil suit in Alipur. I am saying in Alipur. Because of the petitioner was is in distress condition. And he is depending upon.
See, the difficulty is that this is not a matrimonial suit.
No, this is not matrimonial suit. But yeah, other than this suit, there is a one matrimonial suit, one money suit, one another, five different. This is the only injunctions. But they have been five various different against all to have.
No, that is, you get hold of the other side. Otherwise, the extension of interim order is difficult.
So I think.
I am passing it over. In the other matter, sources is appearing.
All three others.
Mm.
Three months.
And what is his application about?
Tension.
Very well.
Item number 5, under arbitration.
The other suits are what suits?
One money suit, one title declaration suit.
Who? Money suit in respect of what?
From as a 125 domestic violation by the petitioner. It was a marine. It is defend and support that. Well, I have people one for or invest.
And the third suit?
Third suit is a declaration.
Declaration?
Declaration in respect of where the opposite party said declared their titles.
Declare title, I cannot get it.
The helper, but this doesn't mean.
Opposite party, see, declaration can be sought in respect of a property which belongs to you. Now, opposite party is staying in their own house. So where is the question of declaration title in respect of the?
That's only, that is in health.
Very well, you get the other side.
Item number 5, under arbitration. Item number 6, under arbitration. Item number 7. I'm for the respondents. Item number 6.
Very well, pass over.
Item number 7. Next second, yes, মেনে কাম করে যেটা এসছি কালকে যেটা পাবো তো আছে আইটেম নম্বর 7
আচ্ছা
মেনশন
pass over for.
এক্সাক্টলি
Let it be passed over for the time.
Item number 8.
8, I am for the applicant, my lord, on the last occasion, my lord, I had filed my affidavit of service. It has been delivered on the bank, but my lord, Indian bank, Mr. Thor, my lord, indicated that if I may intimate, if he chooses to appear, my lord, I intimated him, my lord, he denied that he has no instructions to appear.
Divisional application against?
My lord, against that order of DRT, where my lord,
Your properties have been.
all properties I have been, my lord, restrained from dealing with all my properties. So that since they have chosen not to appear, my lord, in spite of my lord deliver, my lord, but I will be praying for a limited stay of the order, my lord, if my lord kindly considers that.
You are appearing? Which one?
Your lordship, back there for the bank Mr. Mukesh Sharma is supposed to appear online, Your Lordship. We undertake to file our wakalatnama, Your Lordship.
No, that's true, but where is, what is your, see, uh, the petitioner is asking, have you read your brief?
Got the brief day before yesterday at night, Your Lordship. We haven't yet got instructions from the bank. Yet.
Oh.
I am only praying, Milord.
See, the difficulty is that praying is very well, but
This observation, Milord, is palpably bad. But Milord, can you only that paragraph? So far as their right to recover from the mortgage property, I cannot stand in the way. But so far as other properties, Milord, this cannot be allowed.
which says, what says? If I have, say, a property which has fetched 1 crore, my dues are 1.5 crores. So cannot the bank proceed against your other properties
Milord,
in execution?
it's not execution. Milord,
This is-
had it been a recovery proceeding, Milord, I could have understood that they have exhausted all their remedies, now they are behind my personal properties. Milord, the tribunal saying that the bank has a right to proceed against the mortgage property. In respect of that, earlier, Milord, in the auction, they had, Milord, recovered their amount. There was a substantial surplus of 7.5 lakhs which was credited back to me. Now, after section 14 order, where they cannot take possession of that property, they again approach the DRT and obtain this order. That property is also encumbered now. I cannot do anything. Mortgage property, bank has a right. They can chase after it for the second time also. But other properties, Milord, how can this be? But I am only praying, Milord, let this portion be stayed.
See, the difficulty is that Mr. Ghosh, I stay that portion, and in the meantime, your petitioner, in the meantime, the petitioner, your client, changes the nature and character of the other properties which are indicated in the order. Then what will happen?
Milord, that is, Milord, a very Milord, an anticipation. Probably, Milord, it is far-fetched at this moment.
You go for a recalling application. Go for a recalling.
Milord, and order, Milord, which is apparently, Milord, perverse. Milord, that's why, Milord, I was only praying under 227. Probably your lordship would be inclined to interfere in this kind of orders. Milord, unnecessarily for this, Milord, kindly, Milord, appreciate the hardship. Unnecessarily for this observation, none of my fault. You recovered the money, you paid me back. Section 14, you did not check the possession status. You did whatever you wanted to. Now, for this portion, you have restrained me. Now, for this appeal, Milord, there is a deposit, Milord. I have to approach a tribunal in Calcutta, Milord. It's a hardship.
Your Lordship, for one, on the first day also, if it's taken up on the next circuit, Lordship, to take instructions from the bank.
The opposite party bank is represented. It is submitted by the bank that it is submitted by the learned lawyer appearing for the bank that the matter may be adjourned till the next circuit to enable her to take necessary instructions. This is the last date of the present circuit. The petitioner seeks for an interim order of stay of the order dated Which paragraph?
My lord, internal page 9, Roman
Four.
4, yes.
কি বললাম তাহলে? An interim order of stay at least to a portion of the order dated judgment and order dated 10th January 2024, which debars the petitioner from transferring, alienating, encumbering, or disposing of any other property and assets belonging to the petitioner in addition to the hypothecated, mortgage properties. The said order is in force for 1.5 years. The কি বললাম? Is in force for 1.5 years and had been passed on an application under section 19 of the recovery of debts and bank debts. কি লিখছে? ডেটস এই ব্যাংক্রাপসি অ্যাক্ট কোত্থেকে পাচ্ছে? recovery of debt due to Bank and Financial Institutions Act 1990.
After coming into force of the IBC, my lord, that name of the act has been renamed. Now it is, my lord, Recovery of Debts and Bankruptcy Act 1993.
But was it filed under the said provision? I am
Probably no, because
that is what I am.
yes, yes.
If it is filed under the old
Old act,
act,
it has to be under the old.
then no. Section 19 of the Recovery of Debts and Bankruptcy Act 1993. Post up. The said order is applicable post. The petitioner has not filed any appeal against the order, against the said order. Moreover, the petitioner has also not filed any application for recalling of the said order or review of the same. Post up. In the aforesaid facts and circumstances, I do not find any urgency in favor of the petitioners to hear out the matter and grant an ad interim order of stay on the last day of the present circuit. Let this matter be placed before the next circuit subject to as convenience. The opposite party bank is granted leave to file Vakalatnama by tomorrow,
Tomorrow is Saturday, Your Lordship, on Monday.
by 23rd, তাই তো? June 20.
I'm waiting.
Gracefully.
Mr. Ghosh
Milord.
did not come to you. Simple thing, appeal that deposit, and but here there is a question of any deposit. Some
They will technically calculate
very
the
well.
value of the amount
But
involved.
recalling application does not require the security.
No, that has not been done. That has not. Been.
Item number 9. Yes. Item number 9. Answer the 1 minute.
Who is for the petitioner?
It was for the appeal of the motion.
Next circuit.
Item number 10.
Lordship, in item number 10, I am appearing on behalf of the appellant petitioner. Lordship, on the earlier occasion, that is yesterday, we have served the copy to the respondent bank. So this matter is being led by Mr. Shamol Dash. So would be grateful if my lord kindly.
Bank appeared yesterday.
No, today bank did not appear. We have served the copy and we have also got a receipt copy.
Next circuit.
Very grateful.
Item number 11.
Item number 11, Your Lordship, I'm led by my senior advocate Amlesh Rai in this matter. He has his legs before the court number 3, Your Lordship. If Your Lordship could pass over for short pass over, Your Lordship.
Where is the question of passing over on the last day?
Your Lordship,
I will be sitting till 12 o'clock, then before to the division bench.
Your Lordship, the item is going on, that's why I could not call him, Your Lordship.
Next circuit.
Okay.
Item number 12. 13. 14. 15.
My lord, I'm led by my learned senior, Mr. Navankur Pal. He's on his legs before court room 3. My lord, praying for a short passover, my lord.
Which is the matter? Number
14.
14.
I don't know 4.
No.
Kindly, my lord, short
Next
passover.
circuit. Next circuit.
My lord, I missed my lord. Am I audible, my lord?
Yes.
My lord, item number 13 was called out, but before I could get connected, it went over. My lord, kindly places in before the next circuit, my lord.
14 for the petition.
14 petitioner is there.
No, he is in 13, I guess.
Mr. Bhattacharya, you are in item number 13.
14.
You are in which number? Which item?
Myself, my lord.
Yes.
My lord, 13.
13 next circuit.
Item 14, 49 for the petition.
Who is for your other side?
No, this is happening for the first time, my lord. I am praying for expeditious disposal of the both the suits heard analogously, one by the husband and another by the wife. Although there was definite direction from this honorable court to dispose of the same within 3 months, that has not been done. The wife has sought for 22 adjournments, repeated. And I shall show my.
But see, in these cases where you are asking for expeditions, the other side is required to be present. You have served.
No, ma. It's a
Let a
motion
copy,
stage.
let a copy of this application be served on the opposite party or parties.
Opposite party, wife.
Opposite party. Let this matter appear in the next
On the first of the next circuit, I shall serve in the meeting.
next available circuit. Subject to, on the returnable date, the petitioner has to file an affidavit of service demonstrating service on the opposite party as opposite parties কি বলে
Demonstrating service on the
before the next available circuit তো বলা হয়ে গেছে চলো
On the first of the next circuit, kindly, my lord. Otherwise, again, I have to mention it will delay, my lord. They are repeatedly seeking time.
Really?
On the first of the next circuit.
Next circuit means the first day.
Grateful. Item 15.
Lordship, in item number 15, I am appearing again on behalf of the appellant petitioner, Mr. Puranjit Patro, led by Mr. Amitabh Ghosh. Lordship would be very grateful if my lord kindly fix this matter in the next circuit bench, as because Mr. Ghosh, due to certain medical exigencies, is not ready to join the matter today. I beseech your lordship. Mr. Amitabh Ghosh is leading the matter.
Next circuit.
Grateful, your lordship.
Item 16. 17. 17. Petitioner, my lord. কত আছে? কত লিখছে? The petitioners. My application under section 10 of the Civil Procedure Code has been rejected. My lord, the plaintiffs have preferred a suit for partition, my lord, whereas the property belonging to their father was already bequeathed in favor of the sons of the defendant number 1, my lord. That was brought on record, and the probate case has also been started. A prayer was made to stay the partition suit. That has been rejected.
The petitioner shall serve a copy upon the
I will be paying for stay of the proceeding. The issues will be framed, my lord. The suit is will proceed, my lord.
No, next circuit. Order to do.
My lord, I will be paying for stay of the. The suit will proceed, my lord.
Next circuit, 10 days after.
Item number 18.
You ensure the presence of the other side.
My lord, appearing for the first time.
Oh, at it order করে দাও তো। Let a copy of this application be served on the opposite party on or before commencement of the next available circuit. On or before the commencement of the next available circuit, let this matter appear before.
What is happening is if a date is mentioned, the matter appears on the date fixed, my lord. Otherwise, again, mentioning speed, my lord.
No point.
Grateful. Item 18, 19, 20, 21, 22, 23, 24.
For the petitioner, Lordship. 24. Lordship,
What is the matter about?
Lordship, this is the matter. 3 দিন ঘুরছে জিদ্দার পিছনে
The opposite party is
Directed to serve the copy.
the opposite party. Now, Mr. Swanso appears on behalf of the opposite party and submits that he has the instruction to represent the opposite party and also seeks for a copy of the application. Let Mr. Swanso is granted leave to file the Vokalatnama by 23rd. Let a copy of this application be served on the learned advocate representing the opposite party. Let this matter appear before the next available subject to its comments.
For 25, 26.
I am for the petitioner, Lordship.
What is the
Lordship, Lordship, it is a section 24 matter. Lordship, we have to brief Mr. Senior Counsel Riju Ghoshal for the matter. So kindly keep it in the
next circuit?
grateful.
Item 27. 27, 28 is the similar matter to the earlier 234.
Where is the other side?
No, it is a civil motion. 27 and 28 is the civil motion.
No, the other one is.
Other one I inform. I can also inform him. He will come. Lordship.
No, it is. You said that between the same parties.
Yes, same party. I am the opposite party, and filed by the in this case defendant is separate. That is one of the husband and another is mother-in-law.
ঠিক আছে কি জানো ওই এটাকে রাখো পাস ওভার করে তারপর দেখছি আর
27 and 20.
যেগুলো পাস ওভার করছি না সব হচ্ছে হবে নেক্সট সার্কিট হ্যাঁ এই দুটোকে পাস ওভার
Item 29 under application serial 30 restoration application B31 32 33 34 contested application 35 36 37 38 non for the opposite. Item number
হ্যাঁ
38 for the obstacle. Number 1. 39 40 with 41 42 with 43 44 45 with 46 47 45 with 46 47
47 next set.
49 50 51 52 53
53 on for the opposite party. Despite there being direction, specific direction to serve copy upon the opposite party, no copy has been served upon the opposite party till date.
মিলেন আইটেম নাম আচ্ছা মিলেন আইটেম নাম্বার 44 Item number 44,
Direction to serve copy upon the opposite party, till date no copy has been served, and the proceeding is stored in the court below.
A reasonable opportunity. And next circuit করুন।
item number 44, the parties are settling. Kindly keep it in the next circuit. Item number 44.
50, 55, 56, 57, 58, 59, 60, 61 under hearing, 62, 63, 64.
Passover গুলো ডাকো।
After item,
Actually, I have informed this. Senior is coming. Yeah, inform me that his senior is. Who?
What?
234.
What do you say? Yes?
Is the claim in put out forward?
What number 4? Is it possible?
Yes.
Yes, what do you say?
Since the earlier. But earlier direction is concerned, my lord, I was, my lord, directed to file opposition, my lord. Lord, my lord, pray for a extension of time, my lord, 1 week, my lord.
This is an application for extension of the interim order, which is in subsistence till 30th June 2025. In the main revisional application by an order dated 19th May 2005, the opposite party was directed to file his his affidavit in opposition. Full stop. The opposite party has not yet filed its written objection. Affidavit in opposition. The affidavit in opposition and is seeking extension of time to file the same. Full stop. In the aforesaid facts and circumstances, the time to file affidavit of opposition is peremptorily extended till 30th. Till 30th June 2025. Let this, you want to file a reply?
Reply, that is within 1 week.
Very well. Reply, if any, thereto by 4th July 2025. Let this matter be placed before the available circuit on 5th July 2020. On 5th July. the interim order, which is still in subsistence, is extended till till 18th August or until further orders, whichever is earlier. In the other matters,
The two matters I have not served, this is a civil motion. I think your client has also filed another two cases. He is no knowledge about that.
ওইগুলোতে ইয়েতে সার্ভ করে আসছে বলো। হ্যাঁ, ওই দুটো নিয়ে নাও আশিস। হ্যাঁ, ও তিন আর চারটা।
আমি না, আপনার client। দুটো ফাইল করলাম।
This is an application for transfer of the suit. Interiorly under section 24. This is transfer. Interiorly under section 24 of the Code of Civil Procedure 1908. Let a copy of this application be served on the opposite party. Let this matter appear before the.
In the meantime, stay maybe.
No. Sorry.
Otherwise, the Lordship, she has to come to Siliguri.
Maybe. Can you give me the date? Next date?
Lordship. 23rd June 2025. 23rd June 2025.
বললাম next circuit bench পুস্তক since the application for transfer is pending, the petitioner will be entitled to apply before the trial court for adjournment of the proceedings on the next date, which according to the petitioner is fixed on 23rd June 2025. ঠিক আছে?
23rd June. Through advocate then.
I am not interested through advocate or through someone.
New case.
এই একই অর্ডার হবে পরেরটাতেও। When is the next date?
26th. 23rd.
Which one? Next also?
Yes.
Are you sure?
I have no date because of this summon has been received just today. I think it will be June or July. I didn't get.
তাহলে ওটাতে ইয়ে হ্যাঁ না ওটা না কি ওই জায়গাটা বড়
Since the application for transfer is pending, the petitioner is entitled to apply before the trial court for adjournment of the proceeding.
If the same is taken before the next circuit.
Passport matter item number 5, arbitration.
My lord.
Yes.
Online.
You are appearing for whom?
My senior.
My lord,
The other
I'm
side-
appearing for the petitioner, madam.
You are for the respondent?
SGI was directed to appear.
Yes. What is the matter about?
My lord, this is an
arbitration for appointment of application for a contractor under the railways. I have done certain works, but the payment has not been made. Subsequently, I've invoked the arbitration clause. They have not replied, my lord, and pursuant to that, I have filed this application for appointment of arbitrator, my lord.
That's led by Master DGI online.
Lordship, only a few days back, my learned friend for the other side, under instructions from my lord, was kind enough to serve me with a copy. I've sent it down to the department. Allow me to file a report, but find out whether the department has initiated some process of appointment of our statutory arbitrator.
No question of appointment.
We have objected to the statutory arbitrator because it's barred.
My
Barred by
lord,
section
my
12.
lord, now my learned friend, once he goes for asks to appoint arbitrator, next he comes up and says, don't appoint an arbitrator, what we should do?
My lord, not as per the statute, my lord. There is a bar of 12.5.
There was a named arbitrator in the contract, my lord.
So now I am appointing the arbitrator. You fight it out before him.
My lord,
No,
this
my
is
lord.
a
My submission
grateful,
is
my lord. I would
he
be
sends a
grateful, my
letter.
lord.
He cannot blow hot and cold.
It will not, Mr. Mojumdar, there will be no hot and cold. You go before the arbitrator, no difficulty.
We are appointing.
No, you cannot appoint.
Why not, my lord? Because the general contract
Yes,
says
my
there
lord.
is a named arbitrator.
See, you have lost that right. The Supreme Court has clarified it not once,
Yes,
twice.
my lord.
I have considered this and I have given a detailed judgment.
My lord, there are counters also. In a
Oh.
lot of judgment, Supreme Court and
Sorry.
High Court has said 12.5 is not absolute bar.
My lord, we
Sorry, Mr.
are
Mojumdar.
not giving consent
Your
to 12.5.
submission is absolutely unacceptable because the Supreme Court, in no uncertain terms, has said the right goes.
No, my lord, I have a right to make submission. It is up to your lordship to accept or not to accept.
Very well. Take down. This is an application under section 6, under section
But
11.
one thing, my lord, kindly records that the petitioner should have some sort of integrity and honesty before coming to the court. They don't serve us properly. These things should be taken into consideration, my lord.
Under section 11 of the Arbitration and Conciliation Act 1996, full stop. The matter arises out of a contract between the petitioner. Now, the disputes arise out of a contract between the petitioner and
General Manager, Northeast Frontier Railway.
Mr. Singhal, please stop dragging in general managers in every drop of the hat. This is a kind of legal arm twisting. You know who is the person. काम नहीं करेगा पैसा नहीं होगा.
where is the contract? Where is the arbitration clause?
My lord, I have annexed the general conditions of contract, my lord.
Which page?
Clause 63, my lord.
Which page? Which page?
42.
Page number 42.
And the T. 42. Serial. Yes.
There's a string in it.
Which page? I'm asking you, which page is the arbitration clause?
Oh, that's it.
You are giving me the first page. Yes, which page is the arbitration clause?
My lord, my junior is assisting, my lord, with the page number, my lord. Clause 6.
খুঁজতে শুরু করেছে। Between the and the Northeastern Frontier Railway. What is this?
Senior division electric engineer, North Frontier, Kathiar Junction.
North Frontier Division of the Indian Railways. Full stop. The contract was the general conditions of contract. The Indian Railways standard general conditions of contract. Published in July 2014, was made part of the said contract. What is the date of your contract?
July 2024. July 2014. July 2014.
Which date? There must be a date.
Lordship, দেখতে তো জানি।
কি বললাম?
Standard general conditions of contract published in July 14 was made part of the state contract.
Was made part of the tender bearing number 30-2018, which culminated into the contract between the parties on the petitioner's offer being accepted. Full stop. Clause 63 of the said standard year provides for কি বললো?
Was 16th of this year. Provides
For settlement of disputes. Full stop. The said clause in respect of certain issues provide that the contractor has to approach the এটাকে সেট আউট করে দিলে সবচেয়ে ভালো। হ্যাঁ, পুরো 62তেই সেট আউট করে দিল, which provides as follows, ঠিক আছে? না, এটা এইভাবে করবো। কি বললাম, সেটেলমেন্ট ক্লজ 60। না না, কি বললাম তোমাকে? হ্যাঁ হ্যাঁ হ্যাঁ
disputes.
হ্যাঁ, settlement of all disputes and differences of any kind whatsoever arising out of the arising out of or in connection with the contract, whether during the progress of the work or after its completion. Or whether before or after determination of the contract. Full stop. The contractor, in respect of a dispute, has to approach the general manager of the concerned railway, who
That
shall,
we have done, my lord.
who shall, within 120 days from the date of receipt of such representation.
General manager has got nothing to do with appointment of arbitrator.
See, just a minute. Mr. Mujumdar, I am quoting the contract itself. I am quoting the contract itself. কি বললাম? Decision, full stop. Except those matters which are not arbitrable in terms of the said standard general dispute in respect of any other issue, any other issue on the issue which is not acceptable issue কি বললাম না issue না একটু আগে থেকে পড়ো না না ওখানে ওটা কেটে দাও ডিসিশন থেকে পরে কেটে দাও ইফ দি কন্ট্রাক্টর is dissatisfied in respect of such decision, say when accept the matters which are not arbitrable under the said conditions of contract, or in the case the general manager does not dispose of the same, may seek for can seek for appointment of arbitrator in terms of clause 64 of the said conditions of contract. Post. Clause 64 within bracket 3 provides for appointment of arbitrator. The appointing authority in case of disputes in excess of rupees 25 lakh, ঠিক আছে 5টা শূন্য, is the কি বললাম is the general manager and the arbitrator shall be a gazetted officer of the railway not below one A grade. Not below 3A grade. Post. In the instant case, the petitioner has fulfilled the condition of section of clause 63. Post. of the set conditions of contract. ঠিক আছে? The petitioner now seeks appointment of the arbitrator. It is well settled in view of the judgments reported. ওটা blank রাখো, that 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 the general manager is precluded from appointing an arbitrator in view of the provisions of Section 12 within bracket 5 of the Arbitration and Conciliation Act. The in the aforesaid facts and circumstances, after considering that there exists an arbitration agreement between the parties, the claim of the petitioner is not stale or long barred claim, and there is a there is a proper and valid notice invoking an arbitration, invoking the arbitration agreement. I am inclined to appoint an arbitrator, overruling the objection raised by the respondent dash railways. That they intend to appoint an arbitrator. This is more so because the appointing power or the power to nominate available to the general manager under the said conditions of contract is no more available. In the aforesaid facts and circumstances,
Lordship, my lord's voice is fading, my lord.
Mr. Mojumdar,
Lordship.
can you jointly suggest a name?
My lord, now since your lordship is exercising my lord's power, that will come from the pen. That will be coming from the panel, my lord. Now, if Mr. Singhal is his client is agreeable to pay the fees, obviously then it should be a retired High Court judge.
No, fees will be paid by you also. Why not?
50%, my lord, Union of India doesn't run short of money. It is a private person.
My lord, then union can clear our
You don't complete the work within time and then come and ask for money.
My lord, no, my lord, we have
You
already
are
completed the
blacklisted,
works, my
Mr.
lord.
Sinhal, you are blacklisted.
My lord, this is coercion, my lord. On the face of record, my lord.
You were blacklisted by the department.
MS Samapti Chatterjee, a former judge of the High Court.
Samapti Chatterjee, my lord?
Yes.
Lordship.
Tell me, I am open. Still now I am open. If you
No, my lord, I don't have any such name because I very well know that we can appoint arbitrator away from the department. But then I have to seek suggestion from the department, my lord, that would delay. Section 12(5), my lord, will agree that it bars the department to appoint any person connected to the department in any way, but we can always appoint an independent person.
No, you see, the right to appoint is gone. You will
My lord, I have to look into this, my lord.
You look into the judgment of Justice Nariman, which has been subsequently approved. The right to appoint goes. The arbitration agreement remains. So if the right,
my lord, then in a way the Honorable Supreme Court has struck down 12(5) altogether.
If that is not for me to decide, you take any case to the Supreme Court.
But whatever I last read, my lord, it was that we could appoint arbitrator who is not connected to the department in any way.
You will know.
Anyway, my lord, let us not dwell in this imbroglio right now. We will take a when it comes.
Samapti Chatterjee, former judge of this court, is appointed as an arbitrator. তারপরে কালকের অর্ডার গুলো যেগুলো ছিল,
My lord, I should discharge my duty to the fullest. I pray for a stay of the operation of the order.
No. Acha, later, the learned Deputy Solicitor General appearing for the respondent prays for stay of operation of this order. The same is considered and rejected.
Definitely.
Grateful.
As of today, my lord, it is 3:30 again. Resolution has been passed, my lord, in the principal bench, 3:30.
In this case, I'm for the petitioner, Lordship.
Yes.
Filing the affidavit in reply, Lordship.
Affidavit in reply filed in court today is taken on record.
We have not received the copy.
A copy of the a copy of such a reply is made over to the learned advocate for the is made over to the learned advocate for the respondent in course of hearing. First, the learned advocate for the respondent seeks an adjournment to consider the reply. Let this matter appear before the next.
My lord, am I audible?
Yes.
My lord, since I have got no matters pending before my lords, before I take your lordship's leave, may I be permitted to wish my lord a safe and sound journey back to Calcutta?
Thank you, Mr.
And
Modi.
hoping to meet your lordship on 12th of July again.
Yes.
Thank you, my lord.
One in this, instead of the respondent seeking for it, then let it be both the parties are seeking for it.
No. You have been given the reply in course of. If you are ready, I can take it. I have no difficulty.
No.
This is a section 9 or section 11 application?
11.
Section 11 application opposition.
Item number 7, passport matter and the civil motion.
We're paying for only next circuit. Mr. Tonmoy Rai is appearing.
Next set. চলো তাড়াতাড়ি করো। আর পাস ওভার কিছু আছে? হ্যাঁ, দেখো।
Item number 12, passport matter. 15, 16. Item number 18, 15.
Yes. What is the matter about?
Actually, injunction was refused by the, injunction was granted by the Civil Justice Senior Division, and an appeal was preferred before the learned district judge, and stay was not granted. We have preferred it.
Next subject. I don't have the time to hear it out. ঠিক আছে।
Item number 19, 20, 21, 22, 23, 25, 27, 28.
Item
44, Millard.
No one has responded. It has been made to the next circuit.
So, Millard, I tried to respond, Millard, but there was a glitch.
What?
Millard, maybe.
What can be done?
Millard, it Millard records, Millard, my appearance, Millard.
No.
Item 44.
Lordship, I am for the appeal.
Yes.
This is the second appeal, Lordship, filed by the plaintiff appellate person.
Yes.
Plaintiff filed a suit titled.
Why defective?
I have annexed the certified copy of the judgment
Not
of
in form.
first appellate court.
Oh. This is an application. Now, this second appeal is at the admission stage. It appears from the report of the additional stamp reporter that there are certain defects. The appellant is granted liberty to cure the defects. Let this matter appear before the next circuit, subject to its convenience.
Item number 2, under manual application.
There was direction to file affidavit in opposition, and she has also filed a reply. I had raised a preliminary objection. My lord's order dated 9th June. My lords, kindly have a look.
এই আমার গ্লাসটা আনতে বলো তো। One 41 is on just delay.
Yes. My lord, I had raised a preliminary objection that since they have implemented the order and granted me refund, and the order has been acted upon, they cannot come and challenge that before the.
That is another aspect of the matter.
And they have suppressed.
Why you are opposing the application for condonation of the?
Since this fact has been suppressed.
That is the on merit. That in
No,
spite
no,
of acting upon the order impugned, whether they can paper.
That fact was suppressed in the condonation application, my lord. That was my plea.
Yeah.
My lord, a notice under section 73 was given raising a demand of 6,81,882 by the GST department against the present respondent, the petitioner. Thereafter, what has happened? They did not participate in the proceeding and an adjudication order was passed, against which they did not file any appeal, but they straight away filed a writ. After the appellate period of limitation was over. Thereafter, in the writ petition, they claimed that 73 notice cannot be given without 61 notice, which is a scrutiny. Without scrutiny, you cannot give a 73 notice. So, the Honorable Single Bench has passed an order setting aside the 73 order and directing the authority to initiate a fresh proceedings. Yes. What had happened in between when the order was passed by the Single Bench, after just one day, the order was passed on 23/9. On 24/9, what as per the adjudication order, an amount was deducted from their credit ledger of the petitioner. And as soon as it came to the knowledge of the department, that an order has been passed by the Single Bench, setting aside the adjudication order, the refund has been made. That much is the case. But they did not, they were aggrieved by the order, and hence no fresh proceeding has been initiated, and therefore we have filed this appeal application, So he is, I shouldn't be saying that he is misrepresenting the facts, This is what
Take
has
down.
happened,
Apart from this, you don't have any other objection regarding the condonation of delay.
My point was that, my lords, that the fact that they have acted upon the order and granted me refund was suppressed.
We have
So
not.
their
acted
appeal
upon
has
it.
become infirm.
Take down, take down. Affidavit in opposition and reply thereto filed in court are taken on record. So this is an application for condonation of delay in filing the appeal. On a perusal of the application, on a conjoint reading of the application along with the opposition and reply, we find that the only ground on which the section was opposed. The prayer for condoning the delay in filing the appeal has been opposed relates to suppression of material fact. It is the case of the respondent that the order
वीडियो ऑन
which was the order
इसके बाद
of the learned single judge, which is under challenge, had, where is that order?
The back. The adjudication office is directed to proceed with the matter afresh, after following all provision in law.
কি বললাম?
Case of the respondent that the order of the learned single judge is under challenge.
Had set aside the order dated 6th March 2024, passed under section 73 within bracket 9 of the West Bengal Goods and Service Tax Act 2017, read with the Central Goods and Sales Tax Act 2017 and Rule 142 within bracket 5 of the West Bengal Goods and Service Tax Rules 2017. Full stop. It is also submitted that prior to passing of the order dated 23rd September 2024, being the order impugned, the appellant had refunded the money.
No, my lord. The order was passed on 23/9/2024.
Ah.
The amount was deducted from their credit ledger on 24/9/2024.
It was refunded.
And thereafter it was refunded when they.
কি বললাম? It is immediately. Now it is submitted that on 23rd. It is submitted by the appellant that on 23rd September 2024, the learned single judge had passed the order. On 24th September 2024, the concerned department, without having notice and knowledge of the said order dated 23rd September 2024, had deducted the assessed amount.
1,69,722.
Assessed amount of rupees
1,69,722.
722 from the ledger, from the credit ledger of the respondent, bracket assessee. Immediately after coming into the immediately after coming to know about the order dated 23rd September 2024, the department has refunded the said sum of it is the contention of the appellant that this fact cannot disentitle the appellant from challenging the order of the learned single judge as contended by the respondent. Furthermore, the omission of this fact being stated in the application for condonation of delay cannot be construed as suppression of material fact or or can be construed that the appellant has accepted the order of the learned single judge and have acted upon the same. In response, it is submitted by the respondent that the act of refund in itself amounts to accepting the order dated 23rd September 2024 and acting upon the same. After having done so, the appellant is not entitled to file the appeal, far less the condonation of the post. After hearing the parties and considering the materials on record, we find that the objection raised by the appellant, by the respondent, relates to the merit of the matter, which can be urged and gone into while deciding the appeal and its maintainability. At this stage, we are only concerned about the delay being condoned. The facts of the case, as aforesaid, does not persuade us to hold that the application for condonation of delay should be disallowed on the grounds urged by the respondent poster. The grounds cited for the delay are satisfactory and they demonstrate the reasons for which the appellant was prevented from filing an appeal within the prescribed period. The application for condonation of delay in filing the appeal being CA 1 of 2025 is, therefore, allowed. The delay is condoned, delay is condoned and the appeal is admitted, The condonation of delay or the appeal or the admission of the appeal will not disentitle the respondent from taking the point of maintainability of the appeal on the ground that the order appealed against has been accepted and acted upon. And so is accordingly disposed of.
My lord, let there be a direction to file paper books.
Yes. Since the appeal has been admitted, the same has to be heard. The department is directed to prepare sufficient number of paper books as expeditiously as possible. See, our query is, since the appeal is a latest patent appeal, the writ petition, opposition, everything is available with you. You can prepare an informal paper book. Very well. The appellant is directed to prepare informal paper books, sufficient number of informal paper books after having the index of the papers to be included in such informal paper book settled through the respondent poster. The settlement of index shall be made within a period of 3 weeks from date. The paper books shall be made ready within a period of 3 weeks thereafter. Once the paper books are prepared, the parties shall be at liberty to mention the matter, mention the appeal for being enlisted for hearing.
Grateful.
I'm grateful.
Okay, हाँ, मिल रहा है.
Number 3 under randomized application.
My lord,
My lord-
item number 3, Mr.
Lordship, I represent the state in this matter, Lordship.
My lord, item 3, I appear for the appellant. My lord, the appeal was taken up, my lord, by your lordship on the last occasion, wherein, my lord, it was directed, my lord, the contempt appeared yesterday only, and the entire payment was made by the municipality to the writ petitioner. So as on today, my lord, there was no due of the writ petition.
Payment to the petition is already paid by the municipality.
Yes, but my lord, the thing over here is that the impugned order against which my lord this appeal was preferred was, my lord, the order dated, my lord, 3rd of April 2025. That is, my lord, annexed with the memorandum of appeal, wherein, my lord, the learned trial judge had directed, my lord, the erstwhile chairman of the municipality, my lord, to furnish his affidavit of assets, disclosing the assets before the court. So, challenging that order, this instant appeal was filed.
Yes.
Yes, my lord, if
it is submitted,
Because there is no requirement.
it is.
very deeply obliged, your lordship.
And do you still want to proceed with the appeal?
No, my lord, in case, because the learned trial judge, what happened, my lord, yesterday when the matter was called on and the fact of the payment of the entire dues was submitted to my lord, then my lord Justice Sinha, my lord, became very angry to the fact that I have not filed the affidavit of assets and have challenged her order before this appellate court. And my lord had fixed the matter, kept the matter, my lord, on 3rd of July for this, only to the restricted purpose of filing of the affidavit of asset. And I duly mentioned before my lord that the appeal is pending and the appeal is fixed today. So that is why my lord has adjourned the matter till 3rd of July. My lord, my contention is that the impugned order, the order of writ, wherein, my lord, specific directions were given to the municipality to pay off the amount. Immediately thereafter, my lord, I was suspended from the party, and my lord, I was suspended I was thrown out from the post of chairman, and the vice chairman took over. Thereafter, my lord, few payments were made by the municipality. So it was impossible for me to carry out with the order, your lordship. It was my duty to carry out with the order of the honorable court. I tried my best. But once I am thrown out of the municipality and I do not have any right or any power to exert, my lord, I cannot pay on behalf of the municipality. That was my contention before the learned single judge, your lordship. To that effect, an affidavit of compliance had also been filed before the learned single judge. My lord, in spite of filing that affidavit of compliance and narrating the entire incident and the incapacity of the erstwhile...
Just a minute.
My lord.
Now the direction was upon the municipality to pay.
Yes.
Now, which is the order wherein you have been directed to file the...
Yes, my lord, the order dated 3rd of April. That is annexed with the memorandum of appeal, your lordship. The memorandum of appeal.
বিলটা হচ্ছে যে আমরা তো বলতে পারবো না ও টাকা দিয়ে দিয়েছে এটা রেকর্ড করতে পারি, কিন্তু আমরা বলতে পারবো ওটা তো ওই জজের ডিরেকশন, সেটা আবার কন্টেম্পটে। উই আর নট সিটিং ইন অ্যাপিল ওভার দি কন্টেম্পট।
No, your lordship is sitting in appeal over the order passed in contempt only.
No.
Yes, your lordship. The order dated 3rd of April 2025 was passed in contempt proceeding, wherein, my lord, in spite of filing my affidavit of compliance stating that the order of the writ petition has been filed in my capacity as a chairman, and in the capacity of chairman only, I have been made the contemptor, not in my personal capacity. So once I am thrown out of the post of chairmanship, suspended from the party, and the entire helm of affairs, my lord, shifted to the vice chairman, my lord, I become powerless, my lord, to comply with the order of the court.
Just a minute.
That is what, yes.
Lordship, am I audible, Lordship?
Your lordship is on the order dated 3rd of April.
Yes.
My lord, the 5th paragraph, my lord, says, in that very order, my lord, the new chairman has
Please,
also been.
please, please,
Yes, yes,
please.
my lord. I am sorry, my lord. I am sorry. I'm sorry. I'm sorry, my lord. I could not properly see, my lord. I'm sorry.
Where is the order directing the issuance of rule?
My lord, I did not get that order, my lord, but a rule was served to me wherein, my lord, I filed my affidavit of compliance. Kindly see, my lord, page 57 of the CAN application.
Mr. Mondol,
My lord.
there has to be a order which directs issuance of rule, which is
Yes, Your
followed by the rule. The rule is served
Yes.
upon you.
No, my lord, the rule has not been served upon me, my lord. I was made the contemptor in during the pendency of the contempt application, my lord. I was removed from the post of chairman.
Because we need to look at the dates. When was the rule issued?
My lord, may I assist your
Because-
lordship to that?
No, that
My lord, kindly sees, my lord. My lord, kindly comes to this. My lord, order dated 19th December 2024 at
Where-
page 53, annexure E of the CAN application, your lordship. Yes, my lord, in the CAN in the compliance affidavit, I have stated the date at paragraph 2 that your lordship will find at page 57.
just a minute.
Yes.
Where is the order of order of 6 July?
My lord, 6th of March, 6th of March, your lordship.
Where
My
is
lord,
that order?
My lord, that order has not been annexed but duly mentioned in my compliance affidavit.
No, we want to see. Do you have a copy? Your juniors are here.
Whether the rule was issued, the order for the rule was issued on 6th of March.
Yes,
Yes.
6th of March.
That is the order my lord is wanting.
I'm asking for the
Contempt 6th March order ta ber kor first.
This is an appeal arising out of an order.
till 2000.
Yes? Yes, give it to. Not to the-
6 months.
কি বললাম?
This is an appeal arising out of an order dated 3rd April 2025.
3rd April 2025, passed in WPCRC 3 of 2025. The contempt arose in connection with the violation of the
CRC 29 January 2024. Mission of the order.
no.
Yes, my lord. The lead WP 116 of 24. So
29 January 2024. That your lordship will find at page 17 of the CAN application.
পুরো ঘাঁটছে, দেখেছো? ঘাঁটছে, ঘেঁটে যাচ্ছে।
I'm sorry, my lord, I'm sorry.
এটা একটা ভালো কপি দেখলাম না কোথায়?
এই যে 17 পাতায় আছে।
17 পাতায় খারাপ কপি, একটা ভালো কপি এক্ষুনি দেখলাম।
My lord, may I assist one thing to your lordships?
Just a minute, please wait.
Okay. Very well, very well.
হ্যাঁ, কি বললাম?
This is an appeal arises out of an order dated 3rd April 2025 passed in WPCRC 3 of 2025. Contempt arose in connection with the violation of the order dated
29th January 2024. Passed in WPA 116 of 2024, by which the writ petition filed by Swapon Bhaumik was disposed of inter alia, directing the chairman, directing the municipality. Which municipality this is?
My lord, Mal municipality.
Directing one municipality.
To clear the due amount of the writ petitioner, bracket is Swapon Bhaumik, amounting to rupees 25,06,962 positively by 31st May 2024. The municipality paid a sum of rupees paid a sum of rupees 8 lakhs.
But the entirety of the payment is done.
8 lakhs, but failed to pay the balance amount. As a result whereof, the contempt petition was initiated.
So, Your Lordship, contempt initiated first. During pendency of contempt, this first 8 lakhs was paid.
The
municipality paid a sum of rupees 8 lakhs, but failed to pay the balance amount. As a result,
balance amount which কি বললাম ওইটা কি বললাম
municipality paid a sum
না না ওখানে municipality failed to pay the money as directed, as a consequence whereof the writ petitioner filed a contempt application being CPAN 41 of 2024. During the pendency of the said contempt application, the municipality paid a sum of rupees 8 lakhs. And sought for further time to comply with the order. The prayer was considered and the matter was adjourned, and the contempt application was adjourned till 6th March 2025. On 6th March 2025, no one appeared. as a consequence whereof the learned judge issued a contempt rule.
My lord, before that date, I was removed from the post of chairmanship.
It is the case of the appellant that he was removed from the office of chairman on 31st January 2024.
25.
25. And what do you say? This is 20, sir?
No.
No.
My lord, tell me, my lord, my lord.
You are thoroughly confused, and
No,
you
no,
are
no, my
also
lord.
trying
No,
to convert.
no, my lord. May I, my lord. My lord, the order your lordship just referred, dated 19th of December 2024, after the payment of 8 lakhs. Kindly look at that order, my
See,
lord.
we have gone up to 13th of 6th of March.
Prior to that, my lord, I was removed from the post of chairmanship
Yes.
on 31st January 2025. And 7th of February, the vice chairman was appointed as the chairman. 2025.
I have noted the date. Sorry.
Yes. Proceedings were initiated against me from September 24. That your lordship will find at page 55, 56. I have been suspended from the party and my charge was taken over. Unofficially.
ওর পার্টি কি করেছে সেটা নিয়েও এখন
No, my lord, my contention was that I was made powerless. I was made powerless. Even if I wanted to comply with the order, I could not. 55 and 56 kindly sees once.
Will you please
My lord.
yourself?
Absolutely, my lord. Absolutely.
If I need your assistance, I will ask for it.
Very well, my lord.
সাজাতেই দেবে না ফ্যাক্টস গুলোকেও।
Sorry, very sorry, my lord. Very sorry, my lord.
বললাম না ও একটু আগে যাও তো, কিচ্ছু বলছে না, পড়েইনি কাগজগুলো সব দুমদাম বলে যাচ্ছে। এর আগে একটা অ্যাপিল ফাইল করেছিল এই 29-এর অর্ডারের এগেনস্ট। হ্যাঁ বলো হ্যাঁ
অ্যামাউন্ট পেড ওটা কন্টেম্প
না আগে আগে যাও
পিকচারের অর্ডারটা ওটা একটা ডিভিশন বেঞ্চে অ্যাপিল
হ্যাঁ রিট পিটিশনে বলে arises out of
which was upon
হ্যাঁ
This is an appeal arises out of an order dated 3rd April 2025 passed in WPCRC. The contempt arose in connection with the violation of the order dated 29 January 2024 passed in WPA 116 of 2024. Filed with the writ petition was filed by Stockholm was disposed of. Inter alia, directing Mal municipality to clear the due amount of the writ petition and Sopon Gomi amounting to rupees 25 lakhs 6,962 positively by 31st March 2024.
ঠিক আছে এবারে ওটা কর
হ্যাঁ
this order this order was challenged by the Mal municipality by filing an appeal being MAT 42 of 2024. Full stop. The said appeal along with the connected applications were now was disposed of by an order dated 30th July 2024 upholding the order of payment directed by the learned single judge. However, the time to make payment of the amount so directed by the learned single judge was extended for a period of 2 months from the said date. এরপরে কি আছে দেখো তো
municipality failed to pay the money as directed as a consequence whereof the
না municipality failed to pay the money even within the time period extended by the division bench wide order dated 30th July 2024. তারপরে ওটা আছে
pay the money as directed বলবো না even up
হ্যাঁ তারপরে কি আছে বল
as a consequence whereof the writ petition was filed the contempt application.
contempt
আগে ফাইল হচ্ছে তারপর আপনি ফাইল এই দেখাচ্ছি
কবে কন্টেম্পটা ফাইল হয়েছে
এখন পিটিশনের ডেটটা দেখাচ্ছে 10/6 contempt was filed earlier then appeal was filed oh sorry appeal was disposed of on July which was filed first contempt or appeal
My lord, contempt appeal was filed first, and thereafter contempt was filed. I could not pay within the time limit as directed by the appellate court, honorable appellate court. Then only contempt was filed.
okay
As a consequence of during the pendency of the said contempt and reason municipality paid somehow we say that and sought for further time to comply with the order. The prayer was considered and the contempt application
was adjourned
until 6 March 2025. On 6 March 2025, no one appeared as a consequence whereof the learned judge issued a contempt rule.
Full stop.
But it is the case of the applicant that he was removed from the office of the chairman on 31st January 2025.
হ্যাঁ কি বললাম
Last look at the on March 2025, no one appeared as a consequence of the judge issued the contempt.
You just open the lock. Lock. You have got the order?
Yes, ma'am.
Not it print out. হ্যাঁ কি বললাম দি কোন মার্চ না ওর আগে তো
On 6 March
হ্যাঁ
2025, no one appeared as a consequence of the judge issued a contempt rule.
contempt rule নিচে দেখো contempt rule which was made returnable on 3rd April 2025. On it is the case of যেটা ছিল আর কি আচ্ছা as recorded in the order dated 3rd April 2025. That the appellant was removed from the office of chairman on 31st January 2025. And a new chairman was appointed on 7th February 2025. The learned single judge in the order dated 3rd April 2025 had categorically recorded that despite specific direction from the appellate court না কি বললাম
Learned simply judge in the order dated 3rd April 2025 had categorically recorded
that despite being given sufficient opportunity the order of the court was yet to be complied with. Only partial payment has been made by the municipality and the balance payment is pending for considerable period of time. The learned judge therefore directed the appellant, being the erstwhile chairman of Malbajar municipality, to file an affidavit of assets disclosing his assets before the court. Full stop. We do not find any infirmity in the said order as the learned judge, as the learned single judge had given sufficient opportunity to the Mal municipality and its chairman to comply with the order dated comply with the order
29th January 2024.
29 January, which was
January
4, which was affirmed by the appellate court. First, the appellant says that since he was removed from the office of chairmanship, he did not get sufficient opportunity to comply with the order. This contention is also not well founded, as he has been removed only on 31st January 2025, while the order directing payment is dated 29 January 2024. And as such, there was a gap of more than 1 year.
My lord, on 24th September, I was removed from the party. That I have mentioned, my lord.
Your party, whether you have been removed or not, how we are concerned, it is an internal arrangement in
No,
your...
my lord, my power was taken away. That was there. That came to the in the newspaper as well.
We are not, you have been removed as recorded in the order 31st January.
That is so. Officially, I was removed from the
Yes.
post of chairman.
Very well.
But prior
Very
to
well.
that, my power was curtailed. My lord.
Very
That is
well. Very well. কি বললাম তারপর?
This contention is also not well founded, as he has been removed only on 31st January 2025. The order directing payment is dated 29 January 2024, and as such, there was a gap of more than 1 year.
Poster. A contempt proceedings by nature is between the court and the alleged contemners upon the act of contempt being brought to the notice of the court. The learned single judge therefore was well within our jurisdiction to call for to issue rule, and when the answer to the rule was unsatisfactory, direct the appellant, being the erstwhile chairman of Malbajar municipality, to file an affidavit of asset disclosing his assets before the court. It is well settled provision of law that the dignity and majesty of the court is required to be preserved and protected. If a litigant fails to comply with the order, the courts are empowered, the High Court is empowered to deal with the contemners in exercise of its jurisdiction under Article 215 of the Constitution of India, read with the provisions of the Contempt of Courts Act 1971. Post. It is apparent from the facts as stated herein above that the order dated 29 January 2024 as upheld by the order of the division bench dated 30th July 2024 was not complied with till till 3rd April 2025. It is submitted by the appellant, which is not disputed by the petitioner, by the writ petitioner, by the writ petitioner and the petitioner in the contempt application, that the entire dues as directed to be paid by the order dated 29 January 2024, read with the order dated 30th July 2024, has been made on
18th of July.
On 18th of
July. June. Oh, sorry, June.
On 18th of June 2025.
It is submitted by the present chairman and present municipality, not the appellant. Appellant is the asked chairman.
The appellant, I mean, recording the case of the appellant, it is his case that entire amount has been paid.
Yes.
ঠিক আছে? The coterminus in respect of a contempt proceedings is the date on which the violation has taken place. The violation of the order dated 29th January 2024 had taken place July অর্ডারটা কোথায় গেল? জানুয়ারি হচ্ছে 17 কথা। On expiry of 31st May 2024. And again, on expiry of 2 months period from 30th July 2024. Post subsequent compliance of the order, however, does not absolve the act of contempt. We are therefore unable to interfere with the order dated 3rd April 2025. The appeal therefore stands dismissed. The dismissal along with the connected application. The dismissal of the appeal shall, however, not stand in the way of the appellant in praying for dispensation of filing of the affidavit of assets by the before the learned single judge in the contempt proceedings.
Mr. Boni, item number 4. Item number 4, restoration, final restoration application. Oh. Good. Who is the other side? Email by
Who is your other side?
Already execution of service has been filed by email. Actually, in the case of revenue department, more than 5 crores vaccination was practically my junior being AOR on the very day you were still in. You can access.
This is an application for readmission of the appeal and restoration of the any connected application.
No, it's a appeal made application.
Whether in connection with appeal, any application was filed?
No.
Okay.
In connection with the appeal, no application.
Okay.
Huh?
You were there with
No, it's connected.
That's why you were like a function traffic. And I was out of station. That's why this.
কি বললাম?
Oh, yeah, this no be. For recalling the order.
Readmission of the appeal which was dismissed for default on on 18th June 2025. 13th June 2025. Full stop. The affidavit of service filed in court is taken on record. On the said affidavit that a copy has been served through electronic mail. You did not file it. How could, when did you file it? On 18th. On 18th June 2025, informing the respondents that this application will appear in the list on 20th June 2025. The application sent through postal mode, however, has not yet been received by the respondents. Postal. In the aforesaid facts and circumstances, since neither the appellant nor the respondents were present on the before this court on 13th June 2025, when the matter was when the appeal was dismissed for default, we recall the order dated 13th June 2025 and readmit the appeal to its original file for being heard. The application being such and such is accordingly disposed of.
There was a direction to find epidemic that figure of the kind.
No. Yeah, after the recess. After the recess, let me come. I told them I have considered the constitutional validity of the notification dated 24th of February 2021 as directed to be considered by the division bench. I have also considered the letter dated 18 June 2024, which is also subject matter. After this elaborate discussion, I have dismissed the writ petition. But I have given a direction for payment of the retirement benefits to the petitioner, which has accrued up to 31st December 2024 within a period of 8 weeks from date, if not already paid, failing which the petitioner shall be entitled to interest on and from 1st January 2025. Thank you. Yes, that I am correcting it. It has been dictated, only corrections. I have to upload it. This I have to pronounce. That's so. No. Nothing, nothing that unusual or exceptional. It is our duty to discharge. In course of discharge our duty, we do discuss. I also discuss now the legal views as expressed by the advocate and myself get exchanged. Like in all court, nothing exception. Very well. Thank you.